Okay, leaving that regulation behind and starting with a new one. This is the one, they've entitled it Professional Standards. This is the regulation that most contains the substantive regulations of you as a real estate licensee, other than advertising. Advertising was its own creature, but here's almost everything else. And one interesting thing that they did is there used to be a specific regulation that prohibited referral fees to people who were not licensed. Well, they took that out, and instead what they've done is what you see in red here is basically referred to Respa, and that in effect does the same thing. So, and of course, Respa does much more than that, but it also would explicitly prohibit referral fees to people non-licensed. Explicitly excludes, though, paying referral fees to other brokers. Of course, you can do that. It is illegal for you to refuse to show prospective property without the written and signed direction of the client. But even then, you can't have unlawful discrimination. It's illegal to offer real estate for sale or lease without written consent from the persons or entities authorized to sell or lease the property. Again, can't imagine why you would ever think you could anyway, but they've made it explicit, and this has been around for a while, which is why it's all in black here, black and white. The 6 fiduciary duties that you owe to your clients, the so-called old CAR duties. I'm going to read them in the old CAR version: obedience, loyalty, disclosure, confidentiality, accounting, reasonable care, and skill. So you've had those for quite a few years now. To prospective clients. Now here's something that is kind of new. Remember, a prospective client is somebody who's not a client. You tried to make them a client, or they shared confidential information with you. Either one of those things happen. That makes them a prospective client. And to those people, you owe the duties of good faith, fair dealing, and confidentiality. That's it. You don't owe them the 6 duties. You just owe them these 3. And to the consumers of the world, people that you don't represent and they weren't even prospective clients, you just owe the duties of good faith and fair dealing. So that's been around for a while. The regulations specifically make it a violation of law to be in a team relationship without the written consent of the broker. So they're going out of their way to make that clear. And they've gone out of their way to tell us that if the duty of confidentiality exists, it survives the termination of the agency relationship. So if you ever knew anything confidential, even after that client is no longer your client, you still have the duty of confidentiality. We've actually have been teaching that in core classes for probably decades, but now they've made it explicit in a regulation. You're allowed to advertise your fee, certainly, and it's not improper to use a registered nickname in place of your first name. So I think that means my middle name is a nickname. Anytime you're dealing with the commission or in advertising, but it's got to be registered. The duty to submit written offers is if you're a listing, if you're in a listing agreement or any other written agreement by which you agree to provide brokerage services. So you could be a buyer broker. Unless the client specifically waives it in writing, you have the duty to submit offers without delay. I'm going to back up again and just show you that they did something that we thought they could, we've always thought you could do, which is the client could tell you, don't submit them to me. We talked about that early on. So if you've got a waiver in writing from the client that says, don't give me these offers until Sunday at 5, you can honor that. Otherwise, you need to submit them all without delay. And you've got the duty to assist your client in developing, communicating, negotiating, and presenting offers. I think you've always known that you needed to do that. Answer your client's questions. Now, the broker or an affiliate of the broker who represent a client shall, again, without delay, submit all written offers. And here's a big new one that's applicable to everybody. If you didn't do anything else out of this seminar, of course, the advertising is also very important. But this one is totally new, a totally new requirement. So please print it, circle it in red, stick it on your wall, whatever you got to do. And it's a little wrinkly, it's a little interesting. A licensee representing a seller, so you're a listing agent, shall, that means it's mandatory, submit a notice in writing to the licensee representing the buyer of the date and time when the offer was presented to the seller. So you've always been required to submit offers to the seller without delay, subject to their written direction. Now you are required to, in writing, give notice to the person who represented a buyer who tendered that offer. In writing, tell them the date and time when that was presented. I think that you have probably, as a matter of professional courtesy, been doing something very similar to this, but you've probably done it verbally. And so you have to do it in writing to comply. And the other thing that, just not to be overly paranoid, but just to be compliant with the regulation, I do not think, now let me say a text or an email certainly counts, that's in writing, text and email is in writing, but I do not think a text or an email that says, John, I got your offer and I just submitted it to my client. I do not think that complies. And I know that sounds a little crazy, but the regulation says I'm supposed to tell you the date and time. And the reason just now is not really the date and time is, yeah, the text or the email are dated and timed, but we've all had the experience where for me, it especially seems to happen when I go roaming on my cell service, and I don't get texts or emails for 2 or 3 hours, and then all of a sudden I get 50 of them. And it's even happened to me occasionally where I didn't get them for 2 or 3 days, and then I got 150 of them. And so the communication that said just doesn't really tell me what happened. And so I think you need to be very diligent about doing exactly what the regulation says and tell the other licensee the date and time when it was presented. Now, Norman's got a question. Let me see if I can ask to unmute and lower that hand. Yeah, Norman.
Yeah, so in this situation, just got a question, because there are times where the seller requests that the buyer's agent submit the offer directly to them.
Okay.
I may not even know when they get it. So in that situation, I guess it automatically sort of covers itself in that.
I think in that situation you are covered because the whole point is that the agent for the buyer knows when it was presented to the seller, and they're the ones who in that case have done the presenting. So, and you wouldn't know. So I think in that case you'd be covered. I got to think that's pretty rare, isn't it? Though, that the buyer's agent communicates directly to the seller like that. The other thing I want to say that often comes up is somebody will say, well, why do I even need to do this? Doesn't the response take care of this? The seller's response to the offer, because it's dated and timed? And my answer to that, again, being a lawyer, is no, it does not. The only thing that does is tell them when the seller responded to it. It doesn't tell them when it was presented, and that could be days apart. It certainly would be hours apart. And the KREC knew what they were writing, I gotta believe, when they said this. And so they wanted to know when it was presented. Now, the other thing about presented is there's nothing in here that tells us what presented really means. And I would say presented means when I got it by an email, if I'm the client. I mean, I'm assuming that's how you're going to send them to me. I think that is presented. You send it to me in an email, that presented it. And so the other thing that's interesting about this particular regulation, to me anyway, is that it's only the listing agent that has this duty. It's not something that's on the other foot. The shoe doesn't fit the other way. There's no regulation that says that when you're then the agent for the buyer and the seller has made a counteroffer to you, there's nothing that puts a similar duty on you. So it's just interesting that it was only the listing agent who this duty was imposed upon. So there it is. It's totally new in Kentucky. We've never had this or anything quite like it. I will also say, even though this is not an ethics class, I will remind you that the NAR code, for those of you that are realtors, Circle R, which is probably most of you, that the realtor ethics code imposed an ethical obligation last year for something almost identical, but only if the agent who wanted the information asked for it in writing. I don't know if you've had a chance to have an ethics class since that change even happened, and it was mutual. It did go both ways, but that's the NAR code. Every real estate licensee in Kentucky is not a realtor. And Norman, you've got another question, I think. I'm going to ask to unmute you, see if I did that right.
Yeah, I apologize for scrutinizing.
Oh, that's okay.
Sure, on the presented. So let's say your seller works a full-time job. You get the offer at 12 noon, but he's at work. You send it to him via email at 12:05, and then you respond to the buyer's agent saying, hey, I sent it to the seller at 12:05. Today's date, blah, blah, blah. Is that considered presented, or when the seller opens it and looks at it?
I think it's presented when you send it. And there's a lot of statutory law that even talks about things are, I'm just going to say they count when they're sent. And so you may or may not even know when your seller opens it and reviews it, but you presented it, which is the magic word they used when you sent it to them, is my interpretation. Obviously, 20 years ago, presented is when you sat down with them. But in today's world, I don't think you do that often. So to me, it's when it's sent, not necessarily opened. And Keith, I see you've got a question. I'm going to unmute you, or try to unmute you. Did I get you unmuted? I tried to.
Yeah, can you hear me?
There we go. Yeah.
Can you hear me? Yeah, I had a little signal stream problem, so I don't know if this was already covered, but would this again also apply to every counteroffer in a contract negotiation, or just the initial delivery of an offer? And secondly, are we going to start to get into some arguments about what constitutes reasonable time frame for You know, because somebody is going to make a complaint that their offer wasn't delivered in time, and somebody else came in on top of them and got the property.
Sure. And of course, that's what this is all about. You know that without me even telling you. So great questions. Let me make sure I got them straight. First one was, oh, I just lost it because I was.
I, as a listing agent, have
on the
delivered
counter
the initial
offers.
offer, but now there are
Yeah, great. Is it only the first one or is it anyone? The way I would read it, it would be any counter offer, but again, only from the seller side, not the buyer side, right? Which makes it kind of funny to me, odd, but when the offer was presented, well, legally we know that every count or every round in the negotiation is in fact legally a new offer. So I would say every one of those is subject to this regulation. Great question. And your second great question is, in kind of a gap in this regulation is, when is it that Keith, as listing agent, when does he have to send that notice in writing? It didn't say, right? That's what you're picking up on. And it is interesting. It doesn't say that you had to do it immediately. It doesn't say you had to do it without delay or without undue delay. Certainly the safe thing to do would be to do it just as soon as you've sent it to or presented it to your seller. You should immediately send something in writing back to the agent for the buyer. But it doesn't say that. And so, yes, I expect we will get into some arguments about that. Frankly, it surprised me that they didn't include in this regulation the word immediately. I would have thought they would have said that you would immediately have to send that notice, and they didn't. And I see, John, I'm trying to unmute you because I see you, whoops, and then I turned around and muted you again. Come on, Dennis. John has a question. There we go. Now I got you.
So two things. So it's common practice for agents to reply to an offer or counteroffer saying received.
Yes.
We want to comply with this new rule. We need to get in the habit of saying received and presented to the seller.
There you go. That would fix it, as long as it's true, of course.
Yeah. And then the other thing, most people on the Zoom are Louisville, and most people are using showing time.
Yes.
Which has the record of everyone on there. So, you know, never hurts to send out a blanket message to everyone all at the same time. But I guess you know, that you have presented, you have just presented offers to the seller, and the seller is going to respond by a certain time. But I guess to be in strict compliance with this regulation, it has to be one-to-one
right
notification, not a blanket notification.
Right, because if I just got a blanket notification that said that you submitted an offer to your client,
or offers, you know,
offers,
10
I want to know mine has been
right.
presented, and especially in today's world where a bunch of you have been practicing long enough that you never thought you would see what we see today, which is, it's pretty common. I think I saw the statistic, and now I don't remember if this was Kentucky or nationally, that something like 40% of listings get multiple offers. And so it's unheard of historically, but here we are where many listings get multiple offers. And so just being told that offers were presented doesn't tell me that my offer was presented. But great questions also. Another great question. That was great. You all are sharp because you picked up on the gaps in the regulation and the questions that are unanswered. I have a terrible crystal ball. Otherwise, I would have made a fortune in the stock market decades ago. But my crystal ball tells me that this regulation is going to get amended, and I think they'll end up making it mutual so that it's not just the listing agent, but it would be both. And I think they'll probably turn around and end up putting the word immediately in here. Is my guess, but I have no reason to think that that's being considered. It just seems to me like it's something that you and classes before you have all brought that up, that it seems like something that probably should have been done while they were doing it. But we'll see. Well, the only thing constant is change. So we'll see what happens. Here we've got a little bit of direction on transactional brokerage. So we know, we're being told that if you act as a transactional broker, you're to follow the lawful instructions of the parties. Notice they didn't call them clients, they're just parties, and comply with whatever transactional brokerage agreement you're going to have, which probably would be nothing but that agency consent agreement. So we've got, and we've had for decades, a laundry list of things that had to be in listing and purchase contracts. That's still here. It's been changed just a very little bit. For the list, and again, the GLAR contract will comply, I'm sure. The added was the first and last name of the broker is something that has to be in the listing agreement, and the full name of the brokerage. So that's a new regulatory change. Here's something, this is another one of those things that you can read a fair amount into it, is the effective date and time of the listing and advertising if different. So again, I'm listing my property with you, but I'm telling you don't advertise it for another 2 weeks. I suppose you could turn that the other way around and say, here's our written agreement, but I'm telling you go ahead and advertise it, but don't list it for another 2 weeks. Don't know why you would do it that way, but I guess in theory you could. At least the regulation would allow it. Notice that one thing they have taken out of the requirements for a listing is that you do not have to include in a listing the method of canceling it. It always did seem kind of odd that in a listing agreement, at least by regulation, you were supposed to be telling buyers how they could get out of the contract they just signed. Frankly, I don't think many listings really complied with that very well anyway, but now it's specifically taken out. They've made clear that the general description of the real estate sufficient to identify the parcels is what's required to be here. And I see we've got a question. Let me unmute Tim Powers. I'm going to try to lower your hand. Tim, did I get you unmuted?
I believe so.
There we go. Yeah.
The last slide back,
Okay.
you said something about that you may be able to list and not and still advertise early.
There we go. Sorry, took me a minute. Yeah.
Isn't there a time? Don't you have to put the listing into the MLS?
Yeah.
A period of time.
Now here's where things get complicated in the interplay between the KREC rules and the MLS rules. So the MLS rules, which have also recently been amended and tightened effective May 1st. If you remember, the clear cooperation policy got amended effective May 1st. And that clear cooperation policy says within 24 hours of your advertising the listed property, you have to get it on the MLS. That's what the clear cooperation policy says. I think that can be read consistently with this, in that if the property's listed and advertised, then the clear cooperation policy kicks in and your 24-hour meter starts. Somebody asked earlier about, what about office exclusives? Well, that was what that clear cooperation policy was about, clarifying that you can have an office exclusive, but as soon as you advertise it out beyond the office, then the clear cooperation kicked in and the 24-hour clock starts. That is also allowed under this regulation, that you can have a listing and advertising that can be different. And so at least, I know it sounds crazy, but at least in theory, you could have an agreement to advertise property even though you didn't have it listed. So I'm not telling you to go do that, but I'm telling you, at least as far as the KREC is concerned, that's something that could be done. All right, I got a couple of chats finally got up here. I'm sorry. And I got a hand up. Let me look at these chats real quick. But I'm not sharing the PowerPoint. You all are seeing the PowerPoint, aren't you? You see some head. Okay, so somebody may not be seeing it, but everybody else is. So yeah, you may have a view button that you're not. Yeah, thanks for some thumbs up there, folks. Yeah, maybe your view or something. If you're not seeing the PowerPoint, it is truly on your end, not mine. All right, if email or text is not permissible, is there a form for this? Well, okay, their email and text is permissible, so you're covered on that. Somebody did ask earlier, is GLAR going to come up with a form? And I'm assuming what we're talking about is that notice that I've submitted the offer to my client. Frankly, I hope you don't end up with another form for it, because then that would mean another piece of paper that you got to handle, and the reg didn't require a separate form, so why not just make your life simple and do it with a text or an email? Does a delayed showing listing agreement, so that's that office exclusive we're talking about, need to be disclosed as an exclusive agency agreement until it's allowed to be shown? So yeah, that's what this is all talking about here is, let me do that. And I know I've got to, so that's what this is. I mean, you could have those so-called office exclusives where you got a different time of advertising to the public. It could be different than listing. And let's see, I know I've been told I got a hand up. Let me scroll to find it. Bear with me just 1 second here, and then we're probably going to be perfect timing for a break. Lunch break. Well, where did that hand go? Oh, there we go. There's Willie. Sorry, took me a second to find you. Let me click, and I'm going to ask to unmute. Well, Willie, I'm trying to unmute you. I'm sorry. Bear with me.
I think I got it.
There we go.
My question already been answered, was about the offer come in for the seller, or just making sure it's a date time stamp.
Okay. Okay. Good.
That we submitted. So.
Okay. All right. Thank you. Yeah. Yeah. Just so you know, if you raise your hand, it will stay up. You can lower it again, though. You do have that function. The same way you raised it, you can lower it, just so you know, but no problem.
Thanks.
Let's see. I do want to do at least one more slide here, I think. So notice that they added the printed names of the parties in addition to signatures. I guess somebody tried to read something I signed once and had no clue who I was, and so that's why that got in there. They did tell us also it's all parties necessary to effect a sale, including any dower or courtesy. I put in green my smart alecky note that they misspelled the word courtesy. I know that it looks like the way you use the word every day, but the legal term is actually without the O in it. Not that I necessarily expected you to know that, but I was a little disappointed in the compiler of the regulations, who are people at LRC, that they didn't catch it. Anyway, and made it clear also, of course, that you could have the official capacity of a legal representative. So you have LLCs, member, or a corporation, you need to see what their position was so that we don't have to guess about that. We've got special directions of the client concerning limitations or restrictions on showings of property. Again, you might have those. They explicitly took out any limitations on sub-agency None of you have used sub-agency in the way that statute meant for decades, so they have taken that out of there. And the other thing, this will be the last thing we cover before our lunch break, is an offer to purchase shall include a purchase price, or the regulation now makes explicitly clear that you can in fact have a valid escalation clause as long as it's got a maximum purchase price. Now, you all have been using escalation clauses for several years, and GLAR has got a form for that in their forms file for several years. The KREC's position has always been that those were allowed. Now they've made that explicitly clear in the regulation that you can in fact use an escalation clause. Okay, welcome back everybody from lunch. And hopefully lunchtime traffic wasn't a problem for you between your den and your refrigerator. And we're gonna pick it up right where we left off. We were talking about the regulatory requirements for listings and offers to purchase. And specifically here with an offer to purchase, we had just talked about the KREC now allows a valid escalation clause. Also, another change made to make the regulations more consistent with the realities of practice, that a contract deposit, if given, who's going to hold it, and the time period to deliver the deposit. So you've had that in your GLAR contract for quite a while, that you would say how long it was going to take to get to somebody. And remember, way back in the definition section, we talked about you have 3 business days from when you get it to get it deposited. So this is much more easy to comply with and still protect the public with regard to the handling of that money. The first and last name of the agent who prepares the offer, specifically first and last, and date and time and initials of all changes, which you've always needed to be doing anyway, but now it's a regulatory requirement. Specifically, they've acknowledged that you could have a date range of closing, which again is how the realities of the marketplace have been for quite a while. If you had any payment terms, and for the first time, they've got a regulation that says what has to be in a counteroffer. Now, none of this is anything all that earth-shattering, but in the past, there had actually been no requirement about what had to be in a counteroffer. It only said what had to be in an offer. So it's exactly what you would have thought, and certainly the GLAR document complies. Nothing really exciting there. Anything different if not found on the original offer, any change you make. You still have to let people know if you're accepting a backup that there's a prior offer and that it would be contingent. The one thing that's interesting is you still have the same checklist of items that have to be covered by backup, but they eliminated the actual mandatory language. There used to be in the old Reg 250 exact words put in quotes that spelled these things out. Now the mandatory part of the language is gone, but it's still the same information. So if you're using the GLAR backup offer document, you're going to be okay. The other provisions in here about financing are the same. Again, if you had an agreement for rebates and inducements, that has to be in writing. That was also a requirement before, but now put into a regulation. The shall not cross the sign reg is still here. And again, you can cross the sign. You can talk to the other agent's client if that potential seller contacts you. They have to be the one to initiate contact, and specifically calls out that if that happens, you must complete the seller initiated listing form. The KREC has always required that, but they've made that again explicit now in the regulation. Also, in the explicitly made clear in the regulation is that once a listing has expired or been canceled, then anybody can talk to that seller about the property. That's always been true, but they've just made that very clear by this modification to the regulation. The seller's disclosure form has been around since August of 1993, so you all have got your system down pretty well on that by now. Again, they've modified this a little bit to be clear that it's required on duplex, triplex, fourplex, condominium, or townhouse. Remember, those terms all had definitions to them now, as well as any other single-family residential dwelling. And they have updated the regulation to be clear that if you're involved in marketing, brokering a condominium, that you tell the condominium buyer about this certificate. Actually, it says the client. So you tell both the buyer and the seller about the need for this condominium seller certificate and the purchaser's right to void the sales contract under the condominium law for up to 5 days after they get it. Now, prudent agents were always doing this, but now it's been made explicitly required by the KREC regulation. We'll look at that form late this afternoon and see just a couple of modifications made to the form. All right, speaking of forms, the agency disclosure forms that you've been using for the last 15 years, I'll say, pick the date a little bit at random, are the forms you are probably comfortable with, and you are allowed to continue to use those. The regulations have been changed, and the KREC did come up with new forms. And when they originally adopted this, they immediately said, you're not going to have to deal with these new forms until June. But they very recently said, you don't need to deal with these new agency forms, period, until we tell you so. They've put an indefinite delay on them, but I still want to cover what the new regulations talk about on these new forms. So the first thing is, it used to be called the Consumer Guide to Agency Relationships. They've changed the word to Guide to Agency Relationships. That's the form. That's the first form you use early on in the transaction, telling your clients and prospective clients about what agency is all about. The old regulation actually did allow you to make modifications to that form. Almost nobody did, although a few of you had to seek permission. A few of you had gotten permission and put in your brokerage name everywhere it belonged, just to make sure nobody goofed it up. But the new form says you can't modify it at all, or at least it doesn't give permission to modify. I'll put it that way. And the triggers under the new regulation are a little different. It's prior to entering into a written agreement, or prior to entering into an oral agreement, or prior to signing an agency consent agreement. Now, that agency consent agreement is something we're about to talk about. That's the new phrase for what you call the agency disclosure, the substantive agency disclosure. Notice that the two triggers that were removed from that first agency form, they're taken out as triggers, are before you receive confidential information, that is no longer a trigger, and before the end of the second contact, that is taken out as a trigger. And remember, we talked about in seminars for years that these are the two triggers that were almost impossible to comply with, because as soon as your client came up to you and said, I'm interested in buying a fourplex, Tim, and you would say, well, how much you willing to spend? And I say, I'm approved for $300,000. I just told you something confidential, and you were supposed to be giving me that first agency disclosure form before you received the confidential information. So it was impossible to comply. The other trigger also removed, also because it's impossible to comply or very difficult to comply, was the one that said you should provide that form before the end of the second contact. And again, maybe 20 years ago when this reg was first adopted, it made sense because people tended to make one phone call and then meet. But in today's world, you all tell me you do 24 texts with people sometimes before you actually even see them. And so it was very, very difficult to comply with those two triggers. So to the KREC's credit, they've made changes to eliminate those as triggers. So you're not always going to be out of compliance. As always, you've sought the client's signature or prospective client's signature on that guide to agency relationships. And as always, if they don't sign, it's okay. You just hang on to a copy. The regulation spelled out the things, the items that form needed to cover. And of course, their form covers it and has some blanks in there that you do have to fill in about who's your company and who are you, who's your broker. And you can see here the blue, remember, is language gone. So they've eliminated those old guide to agency relationship forms. And as before, you didn't have to use these forms on commercial transactions. Remember, but that definition's changed. You also don't have to use them on real estate at auction, any of you that are auctioneers. But notice that they took out the exemption for property management. So about 1/3 of you said you were property managers. So be aware, for decades, you have not had to deal as a property manager. You did not have to deal with an agency disclosure. Now you do. So you need to be using these agency disclosure forms on your property management transactions. And even though the forms have been indefinitely delayed, you need to use these triggers and you need to follow these exemptions now. It's only the forms that are on an indefinite delay. The agency consent agreement, again, this is what you called an agency disclosure form, the one that we've told you you only did when you had a buyer and a seller, and you disclosed your potential conflicts of interest when there was any dual agency. That's now changed, and it's called an agency consent agreement. Again, this form is on indefinite delay. However, the timing of this one, and the reason it's on delay, is it says you were to give this one prior to entering into a written agreement to provide services or completing a contract. Well, what this means is this form needed to be done before you had them sign a listing. So that's a different trigger than was under that old agency disclosure form. And the problem with the form was it did write blanks set up in it for you to fill it out when you were doing a listing. There was just no way to do it. They just got crosswise. Whoever was in charge of form writing wasn't talking to whoever was in charge of regulation writing. And like everything, you submit it to them, ask them to sign it, and keep a copy. We can look at the form, but you'll see the problem with it. Other than that, it's fine. Other than that, that form did what your agency disclosure form does, which is disclose your known business, family, or personal relationships, and it did that. The thing that it did that's new is to disclose prior contact with a former prospective client who's involved in the presently contemplated real estate transaction. That's a long-winded way of saying that if you are now listing my property and the buyer shows up with an agent and you recognize the buyer as somebody you used to represent or that you tried to represent, you're supposed to be disclosing that to me. Make sense? That's what this new subpart E is about. So that's a new disclosure. That was the other problem with the forms as they were promulgated. They didn't have anything there to deal with this, and it's a specific statute or regulatory requirement, and yet their form didn't meet it. So that's why it's shelved. And the reason these forms are on such an indefinite delay, it's partly the administrative process. At normal times, it takes at least 3 months and sometimes longer to go through the administrative process that is statutorily required to make a change. But because of COVID-19, they're saying that that process is at least 8 months in today's world. And that's from the time that the KREC even has a piece of paper that they're happy with. And as of right now, they don't have a piece of paper they're happy with. The task force has made a recommendation to them, but they still have to look at it and decide if they like it or don't like it. And as you can imagine, trying to get 7 people to agree they like something will take a little while. I'm sure it'll take them more than 1 meeting. And so this is on an indefinite delay until you're going to have to use the new forms. Remember, the form said you used it before you entered a listing or any kind of written representation agreement, and then you update it when that agency relationship later changes, which would happen because when you first list the property with me, I'm the only person you know about, and you're the only person I know about. But then a buyer comes along, and they're represented by somebody else. And so now we've got some change. We've either got dual agency, we got designated agency, we got all kind of things that could kick in that would require a change. So when these new forms get approved, you're going to need to know you're going to end up doing this thing twice. And I ask in particular about how long you were licensed, because I didn't entirely pick those dates at random. You may have thought those were funny dates I asked you about. But the reason I ask those is the cutoff is some of you were licensed more than 20 years ago. And if you were, you remember that that form of the agency disclosure was also a 2-step process where you filled it out initially at listing, and then you turned around and changed it. You edited it when the buyer came along. So this will seem familiar, vaguely familiar to some of you from 20 years ago. Because that was the way that form was set up as far as the timing was concerned. Again, it's got the same changes were made to the exclusions. Like before, you don't have commercial transactions, don't need it. Real estate at auction doesn't need it. But remember, agriculture is now commercial, and therefore it wouldn't have it. And again, the property management exemption was taken out. So that third of you that said you're property managers, you're going to need to deal with this agency disclosure form, even though you're not used to doing that. So what I would recommend you do if you're a property manager is use the old forms and use them on a property management transaction, just like you did on a listing, just like you're familiar with using on a listing or sale. They tell us that your agency terminates on completion of the agreed upon services at the closing. Again, I think that's really what we've always thought it was, but they've again just made it clear by regulation that that is when that agency ends. Another protection for brokers that was added is specifically calling out that the principal is the owner of all written contracts for services. We've always said so. We've always thought that was so, but now the regulation makes very clear that that's so. They go into some detail and tell us when an agency relationship is formed, when you enter a written agreement, and who's who. And other than in designated agency, everybody in a firm has the same relationship with the client as anybody in the firm has with the client. And again, we've always thought that was true, but this just makes that explicit. If your firm represents the seller, everybody in the firm represents the seller, with the exception of designated agency. Remember, designated agency is that different creature where only the designated agent would represent them and the broker. We know that only when, if there's a broker, then they're the principal broker of the firm. If you have additional licensees in the firm that are brokers, then there is still one that's a principal broker, and they're the ones responsible for everything that goes on. Again, making clear that unless your independent contractor agreement with your brokerage says otherwise, then when you terminate your affiliation with the firm, the listings, the documents are all the property of the principal broker, and they need to be immediately turned over, as well as all records, other than, well, just that, all the statutory records. Now, they did call out and say that you don't have to turn over the non-statutorily required records. I guess that means my little Post-it notes all over everything and my phone message slips, if anybody still has those. Those aren't statutorily required, so I guess technically those wouldn't have to be turned over. The KREC made some amendments to the fax and digital transmission requirements. Again, changes that were needed to make the regulations reflect reality. First of all, they eliminated the old reg, that's what the blue is, and tells us that a document by fax or digital shall be immediately placed in the licensee's file. What my note is notice that they eliminated the requirement that you immediately mail a copy of a fax. And I won't embarrass anybody by asking for a show of hands how many people violated the old requirement that said if you received something by fax, you were supposed to immediately mail it. And I don't think anybody in the history of the statute ever did that. Yeah, thank you, John, for being honest. I asked that question at the KREC meeting once, and they all just blushed and put their head down and said, yeah, we'll change that one. So that's eliminated as a requirement. Nobody was in compliance. Notice, brokers, that you still keep documents for 5 years like you always did, excuse me. They've also made clear that you are to confidentially preserve those. Notice that red, so they've added that word. So you don't just preserve them, you confidentially preserve them. And that the 5 years is from either the consummation or the failure of the transaction. It used to just say from the consummation of the transaction. Well, what about the ones that didn't close? You know, what about the ones that got started and, you know, they just didn't all end up anywhere? What were you supposed to do with those? Now it's very clear that also you got to keep those. And there's the same laundry list of documents that you have to keep with some additions. They specifically added that you have to keep the condominium certificate, of course, and then they changed the words about the agency relationship forms, the consent agreement. And here is one place where it does say you keep the timeshare records, even though almost everything else about timeshares is eliminated from the regulations. When documents are signed, you're responsible to see that a copy is delivered to the parties. You're all doing that, I'm sure. The brokers, you're still responsible to see that a closing statement gets prepared. And of course, hopefully you've never had to actually do that yourself, that you've got title agencies, title attorneys, closing attorneys. Some banks themselves did their own closings, but hopefully they've all been doing them, but you are responsible to see that it happens. Brokers, I told you had a couple of things you had to get in writing. One was about your advertising. The second was about teams. So here's another place where they tell us about brokers' responsibilities on teams, that you've got to notify the commission in writing of what is this team's name and who is the team leader before the team is ever allowed to advertise. So that is a broker's job. And if you're, as a broker, you allow teams, here you're required to have procedures for advertising, agency relationships, and handling confidential information, management, and operations. So it puts a lot of burden on a broker here, things that I'm sure you've probably done, but you probably did them verbally, and now you've got to be doing them in writing. So you're going to have some kind of policy and procedure manual for teams. Including having a team leader, regardless of what the business arrangement is amongst the members of the team, and regardless of anything else. The KREC wants to know who's responsible for that team and who are all the personnel. So they've told us licensees, employees, office personnel, clerical staff, who's in the team, all has to be provided to the KREC and maintain a current list of that. The old, I'm gonna sound like I'm repeating myself, and I guess I sort of am. The old unlicensed personal assistant regulation 440 is gone, but here they're telling us that brokers are still responsible to ensure that all employees, unlicensed people, salaried, independent contractors, any way you can think of them, that they are in compliance with the statute and the regulations. So somebody asked the good question is, does that mean unlicensed people can do more? I think the answer to that is no. There's nothing in the statute that says unlicensed people can do anything you're allowed to do. I don't think it means they can do less. It just, this special category is gone, and brokers, you're going to have to make sure that everybody's complying with the license law. Here's the third thing as a broker you're going to need to get in writing. So you're going to have to get yourself a beefed up policy manual. The first was advertising, the second is teams, and here's the third. You're going to need to have in place a written information security system. So I guess in theory we all should have had these years ago. We've probably all done it again verbally, but now you really need to have it in writing about how you're going to keep clients' confidential information confidential. And especially in today's world, we've all got to be concerned about cybersecurity, losing clients, identifying information. And that includes not only the licensed people, but unlicensed people, anybody that can get a hold of any of that stuff, as well as just people breaking in one way or another. And that has to include notification to a client if you become aware of unauthorized or inadvertent disclosure of their confidential information. For what it's worth, Kentucky has actually had a statute requiring this about people maintaining confidential information digitally for quite a while, but this has now been made explicitly a requirement for you as real estate brokers. One recommendation that I've heard sent me is that brokerages tell their clients, don't send me your don't send me your social security number. I don't need to have your date of birth. I don't need to have your bank statements. Those things you need to be sending to your mortgage broker, but don't give them to me. That way I don't have to worry about them getting stolen from my internet system. I think that probably makes a lot of sense. I mean, I know you need some identifying information, but probably not much more than a driver's license with a photo for your own physical safety reasons. Again, designated agents have had to keep their files separate from each other all along. The regulation's been amended to make clear that an individual agent can keep their own file, even though there's a broker file. Individual agents often want to have a file themselves. And again, we've got the typical designated agency regulation that largely has not changed, other than you've made the possibility of a team being in there as well. The third of you that said you're property managers, you're wondering where the property management regulation went, 201 KR 11:245. It's still here. It's now buried here in section 11 regarding property management. So it did not go away, and we're not going to spend time going through it all, but it's almost identical, except almost everywhere they've added principal broker or registered with the commission to be clear who it is that's responsible. And other than that, you see, they didn't make many changes to that other than moving it. Looking through these quickly. Yeah, just again, tying things down as the principal broker is the owner is the biggest thing that's going on here. They did clarify that you have 3 business days from receipt of money to get it into your appropriate account, whatever account it was for property management. All the same record keeping is here. Again, just making it the broker who's specifically responsible for that. Okay, that was that was the end of that professional standards regulation. There's a lot of material in there. Again, if you're a broker, you probably want to pull it out and at least look at those 3 things that you need to get a written standard for, a written policy and procedure for. The next section has to do with education providers. This mostly does not affect you. This would be something Phaedra, I'm sure, studied extensively and I looked at. And so all your various education providers, real estate schools, this mostly affects them. I did not give you all of this, but there were a few things in here that I thought were interesting, that would be interesting to you as licensees. And they combined all the various types of education schools, continuing ed, PLE, broker, and note that the NAR is sort of gets a, I won't say grandfather, but they are pretty much automatically granted approval for their programs if they otherwise meet the standards, of course. And they, just so you know, when the next time you come to a live class here at GLAR, or probably anywhere else, all providers have to have some system by which they assure your identity. Now, we did that by having you register with your KREC license number, and then you were checked in, which is partly a technology requirement, but also does some of this identity. If you come here live, you'll almost certainly be asked to show your photo ID for that same reason. They type at a minimum, you were to sign in and sign out. And by the way, I didn't say so and should have at the very beginning. I want to thank not only Phaedra, but I also want to thank the KREC and Hannah Carlin, the education director at the KREC, for even allowing us to do these classes by Zoom. From a hyper-technical point of view, this might not normally be allowed. And the KREC has specifically granted permission to hold classes by Zoom because of the COVID-19 pandemic. which is something we otherwise wouldn't be able to do. And I know it's a huge administrative burden on FEDRA. And I know that sometimes there's some technology glitches for you and me, but they're bearing the brunt of this. And I'm grateful that we're able to do it at all, because if nothing else, this is a great time to knock out your continuing education. Yeah, there we go. A round of applause. Tim, thank you for those folks. All right, one of the things you're going to notice, if you haven't already, is that your student evaluations at the end are anonymous. You used to fill out, and of course that adds a layer, but you used to fill out one form which had your identity on it and your evaluation. Now, I will tell you, I never saw who said what. It was always, in effect, bifurcated, and I only got the evaluation part, not the who part. But because of this regulation change, it's now turned into 2 pieces of paper. When you fill out your evaluation at 4 o'clock today, it's only going to be your evaluation. There will be no identifying information on it whatsoever. And that's why you'll have a separate affidavit of attendance to show that you were here in addition to the evaluation. So that's something that's a little different. A handful of you attended classes here live and saw that with 2 pieces of paper. Now you're going to have 2 pieces of digital documentation. We're all supposed to be following the GAPE rules for education, and should have been all along, but and we have to submit courses in advance. I think the main point about this I wanted to make is that in order for a class to be taught to you all, I have to write it, or somebody like me writes it. Then we get it to FEDRA, who reviews it and gives us some feedback. Then it has to go to the KREC, the education director there, Hannah Carlin, and they review it and either approve it or not approve it. And the KREC, because of their deadlines, require much advance notice of this. So it's sometimes difficult for us to turn on a dime and get education classes to you about things that are important, just because of the lead time that's required. There are some changes in the exams. Of course, you all are already passed your exams, so you're kind of beyond that. For pre-licensing advisors, some special rules there. I'll probably take that out because you're all licensed. You don't care about that. The KREC has written a Keep Your License Good seminar that people take. They've done that covers a number of topics. And then for PLE people, post-license education people, you know that if you got licensed after 2016, within the first 2 years of getting your license, and that is from the date that your out license was active and placed, you have to get your 48 hours of post-license education. A handful of you, again, the question was kind of worded to catch that, are in that category. Today's class did count for PLE education, by the way. Just a couple of funny things you'll be surprised we even had to have a regulation about. You can only get credit for the same course once. You can't take this class 4 times, which I know John was looking forward to that, right, John? You were really hoping to. You can't do that. Speaking of post-license, another course that occurred at the March meeting of the Kentucky Real Estate Commission, they have put I'm going to call it indefinite delay on when you have to get your PLE done. Now, it's not really indefinite. It's 30 days beyond the end of the state of emergency. So if we had time, I'd ask for a vote on who thinks that's going to be when. So whenever the state of emergency ends, you're then going to have 30 days past then to get your PLE done. I will say this on behalf of anybody who needs to get their PLE done. Don't wait around. It's being taught here a couple of times yet this year. And even if it has to be done by Zoom, it's going to be done. We did cancel half of the March one because it fell right into that state of emergency. But don't wait around, because it'll get a little crazy when the state of emergency does end. So you'll want to go ahead and keep plowing away on those. Also, anybody get it? Now, this is worded funny. I just copied what the KREC wrote, so this is not my syntax. That they're going to extend those who need to get broker education. Now, that's not just licensees, but broker educations, people trying to get their brokers license to 45 days beyond the state of emergency. So if you're in the middle of that, you get 45 days beyond the end to get it done. Not that you have to take that time, but that you could take that time. And again, you can't take the same course in the same education cycle more than once and get credit for it. And again, we've got to get these things all submitted ahead of time. At least 90 days prior to the offering. So it ends up being almost, you know, from the time somebody changes something, it takes almost 6 months for us to get a class to you. The only reason I got this class put together is as they were making changes, I was starting this and kind of had it in the bag. By the time they pulled the button, I was ready to submit. So through Phaedra, and she was great about getting it to Hannah. We got to keep them current, of course, and if we make any changes, then we have to get those approved, just so you know. And every 5 years, we got to submit the whole thing again. And oh, what did I really want to get to? Oh, this would matter, not to you because you're taking this class in June or mid-May. But just half of you said you were brokers, so I'm going to assume you've got people underneath you. Make sure they know, don't horse around and take your continuing education in late December. Education providers have up to 10 days to provide certification that you took a class. And unlike the way it used to be, notice that you took the class has to be in the hands of the KREC by midnight on December 31st. And if it isn't, you're out of compliance. Now, most of these submissions are probably happening electronically these days, so it's not as bad as it used to be, but the providers still have 10 days to get that in. And so if you take a class on December 21 or after, you may have taken the class when you were supposed to and still be fined because you didn't get proof of it into them in time. And this would also, of course, especially be applicable to those few people who are doing things like taking it online on New Year's Eve parties and they don't get the completion certificates in. That's going to be on the student, the licensee, because technically the provider has up to 10 days to do it. We'll see what happens. Some providers, I'm not sure what GLAR is going to do, but some providers have told me they're not going to teach anything after December 21st, just so they avoid the whole problem. And in fact, they're required to give you notice that that might be a problem if you do take something like that. Oh, there's requirements to get what pre-license classes and how many times people can take tests. I'm probably going to take this out. You don't need this. If you're getting a broker's license and you don't pass it all, then you're going to get told what you didn't get and get a chance to work on your deficiencies. I probably do need to leave that in. And there's a bunch of tighter requirements about if you're going to take these tests, where they're going to be proctored and how they're going to be proctored. So make sure nobody's cheating, and that they can't bypass pieces of online exams or online courses to get to exams. And where I'm really trying to get, here's where I really wanted to get. This affects me, not really you, other than hopefully you will notice that your instructors like me get better, I hope. Hopefully continually improving. But starting January 1 of next year, we will have to have completed instructor education. So actually by January 1, 2021, we'll have to have had it for this year. GLAR is providing it here for a number of us, and some of us that are licensed in Indiana already comply with this and take education. And there are some exemptions. So if you get a national level speaker that comes through, which of course happens periodically, those people are exempt from that requirement. Somebody who's only teaching 2 or fewer classes a year, they don't have to go through this. Or somebody who earns the Distinguished Real Estate Instructor designation, which there's a handful of in the state. It's a certification process. Those people don't have to go through this. So we have to have 3 hours of education about educating, and as well as on the substantive law that we're teaching. So hopefully we'll get better because of these requirements as well. Because up until now, there actually has not been a requirement that specific about what you had to do to be a real estate instructor. Obviously, the evaluations do matter, and an instructor who gets bad evaluations can be stricken from the roles if we do anything improper. That can lead to discipline against us as instructors, as it should. And hopefully none of that ever applies. That's the end of that regulation. The next regulation, I want to go ahead and start this, even though we're almost at time for our first break of the afternoon. Hopefully you never need to know a thing about this next topic. It's the complaint and hearing process in front of the Kentucky Real Estate Commission. So I hope this is purely theoretical and never matters to you, but everybody needs to know about it in case it ever does come up. You need to know to deal with this in the proper way. Just a process issue, if nothing else. And of course, there is a complaint process with the KREC. The primary duty of the Kentucky Real Estate Commission is to protect the public. And so there's a way that the public can make complaints against you. And they do that by filing a complaint form that's on the KREC website. And it needs to state what the violation is against a licensee. I will also say this process might matter to you as a complainant against somebody engaged in unlicensed brokerage. So if you ever see anybody brokering who is not licensed, that's something you can file a complaint against, because they're taking money out of your pocket. So you do have the ability to be a complainant in this process as well. So there's a list of things that have to be there. It's very straightforward and simple, but what's the complaint? Who's the principal broker? These complaints are required to be notarized, and there are a number of documents that have to be provided with these, and I do want everybody to pay attention to this document list. Because I will say that over the years, any number of times, my licensee client had a complaint filed against them, and the complaint itself what was stated ended up getting dismissed because it really didn't state a complaint. I'll just make something up and say, she was mean to me. Well, that's not a license law violation. But because of the documents that are required to be filed with the complaint, and we're going to see another list that has to be filed with the answer, sometimes, more than I would like, my client got found guilty of a violation that wasn't even the violation they filed on. They filed the violation saying she was mean to me. That got thrown out, but then they're looking at the documents and say, well, I don't know about her being mean to you, but you never got the seller's disclosure form filled out. And that's a violation. Or you got it filled out too late. That's a violation. So these forms are important. And I emphasize that not to make you paranoid, but just to encourage you to be careful with your forms, be careful with the timing of the forms, and make sure they all get done when they're supposed to be done. So the purchase contract, I'm going to back up, the seller's disclosure form, the agency disclosure documents, a settlement statement, and whatever else there is. There is a good news change for you in here, is that the statute of limitations against you has been shortened with the KREC. And the limitations period used to be 2 years, which meant that 2 years from when the violation was discovered, that's how long somebody had to file the claim. It's now been shortened to 1 year. So there's the good news. It got cut in half from 2 years to 1 year. Now, you already know there's going to be some bad news, because after all, I'm a lawyer teaching the class. So the bad news is it's 1 year, but it's not necessarily 1 year from closing. It's 1 year from when the violation was discovered or should have been discovered. And that's not necessarily closing day. So unfortunately, this 1 year period could be well out there. It's just 1 year from when it should have been discovered. That's what starts the clock clicking that they would have a year to file their claim. So they even tell us actual knowledge of the action, or when the complainant reasonably was put on notice of the action. So unfortunately, it's not really just a year from closing, but at least it is shortened up. All right. Welcome back, everyone. And yeah, 2 o'clock. Okay, we're talking about the complaint process. Again, hopefully purely theoretical for you, but good to know. And when a complaint is received, staff at KREC do look at it and try to make some determination. They clear out a lot of chaff before it ever gets anywhere. So if the complaint just doesn't even appear to state a case, that's what a prima facie case means, is that if the facts stated were true, it would be a violation. If it doesn't, then they send it back and let people, the complainant has an opportunity to file a supplement. And again, the documents that need to be provided sometimes establish complaints when the complaint itself didn't. So we want to be careful with those. You do have the right to file an answer, and the complainant gets to file a reply to your answer. And this goes on and on. You can file one reply to their reply, and if that, all of these have to be notarized and include any documents that are necessary. The regulation has changed and specifically says that for purposes of these deadlines, they will follow the rules of civil procedure, which is fairly technical, but a good thing for you, because in the past, when they said days, it meant days from when documents were dated, and that was unfair to you because you didn't get them for several days, sometimes even a week. So now you clearly have more time to actually get your answers in. You can ask for extensions, or so could the other side for that matter. That's their general counsel would would make that decision. Other than that, there's not going to be any motions with regard to complaints. So even with your lawyer, you're not going to get a dismissal based on a motion. You're going to have to deal with it in a formal way in writing. The entire 7-member commission does not deal with every complaint. There's a complaint screening committee and of up to 3 commissioners, and they go through those complaints, and then they make recommendations to the commission as a whole. And they meet in effect behind closed doors and decide whether they're going to agree or disagree with what their screening committee said would happen. I do want to point out that, again, as much as I hope none of this ever applies to you, if you ever do get a complaint, your E&O coverage does apply, and the E&O carrier will hire a lawyer to defend you. So somebody like me or Jenny Lawson, there's a group of folks that do this on a regular basis, Mike Lawrence, and they will hire them and pay them to defend you on these KREC claims. So if you ever do get one of these, don't wing it yourself. Don't contact the opposing lawyer or complain it and try to talk them out of it. It'll just fan the flames. Contact the E&O carrier, let them do what you're paying your premium for, hire a lawyer to help you with the process. So the complaint screening committee at the KREC does their job, and they decide whether they're going to continue on with an investigation and send that investigator of theirs out to interview people. And if they think there's a fraud issue, then the Research, Education, and Recovery Fund is involved, and they need to know that. And they make a recommendation to the full commission, and then the commission decides what they're going to do. And if they're going to go forward, there's going to be an actual hearing. And you do get a chance to see the investigator's report if they do in any investigation before proceeding on. And of course, the investigator could redact personal or sensitive information in reviewing witnesses. Hopefully, the closest you'll ever come to this process is you might get called by the KREC investigator who will say, you are not the subject of this investigation, but you're a witness. Probably the person on the other side, the agent on the other side might be the subject of the investigation. And part of what they do, just so you know, is interview everybody involved in the transaction, the buyer, seller, both agents. And so you may get called as a witness sometime, and you are required to cooperate with that investigation. So you do get the chance to review the investigator's report and point out what you think are inconsistencies. The investigator is strictly a fact finder, not a decider of who's right and wrong. And if you convince him that he got a fact wrong, he or she will change it. Currently a he, but so again, the commission then has to decide what they're going to do. Do they dismiss it? If they think there's a violation, they're going to go forward with a hearing. And there's an entire administrative hearing process set out by a separate chapter in the statutes that deals with that. And one of the things that the KREC has done for a couple of decades now is before they're going to incur the expense and time and trouble of a full hearing, they are going to engage in some kind of mediation attempt. And I say that the regulation says that they may. My experience is they always do at least try to resolve things through mediation. The mediators come from the Office of the Attorney General, and the person from that office does not report to the full commission, nor do they report to the hearing officer who would ultimately hear the case. They just attempt to reach a resolution. And they have to be somebody totally removed from the transaction, of course, and any commissioner who's involved, because of course the commissioners are licensees of one kind or another. If they're involved in any way, or any of their licensees under them, if they're brokers that are involved in any way, then they're recused from it. The complainant can withdraw a complaint. occasionally that happens after people calm down sometimes. Not very often, frankly, but they can. Also, just so you know, just because the complainant withdraws the complaint doesn't necessarily mean the KREC is going to be finished with it. The KREC may decide, well, Mr. Victim, you're satisfied, but we're not happy. If somebody was, let's say, guilty of fraud and a complaint gets filed against them by a consumer, just because the consumer gets made happy, let's say by the payment of money, doesn't mean that the KREC is going to think it's okay to have an agent out there who's committing fraud. So just because a complainant wants to withdraw doesn't necessarily mean the whole thing's going to go away. Because here we go, the KREC can have its own complaint against the licensee. Again, they do engage in mediation. Here's a pretty substantial change in the hearing process. And I think this is frankly very good for you as licensees, because your fees are what feed that research and recovery fund. And these changes give the KREC the ability, on the very rare occasion it happens, but there have been agents who start running to Belize with escrow money. Obviously, when that happens, the recovery fund gets involved, and that just means you would have to pay more to refund that, refill that recovery fund. So a lot of changes got made to the regulation to give the KREC emergency powers if they think a recovery fund theft is going on, or an escrow violation is going on. So if that violation is occurring, or they think it is, they've got the ability to hold an emergency hearing, which really their regulations didn't provide for before. And if there's been an escrow account violation in excess of $500 or a substantial threat to the health, safety, or welfare of the public, then emergency action can be taken. And the executive director, the chair, and one member of the complaints committee can sign these orders authorizing that. And among other things that means they can do is they could serve that on the bank that's holding the escrow, and they can freeze the money, which of course only makes sense. If somebody's stealing escrow money, the last thing you want to do is have the thief having access to that money for weeks or months while the hearing goes forward. And so obviously this is very rare, but when it happens, there is an emergency provision in place now to deal with that. Let's see. I'm going to read I got a couple of excuse me, chat questions. I'm going to read them out loud with the answers, if that's okay. I won't necessarily say where they're from, but how long do I recommend, or is it required for agents to maintain records? Great question. I'm going to answer, there's two questions and I'm going to give two answers. How long is it required for you to maintain records? The answer is 5 years. So 5 years from closing, or 5 years from when the thing fails to close, you're required to keep your records. Second half of that question is, how long do I recommend that you keep records? You're going to hate this: forever. Because of the discovery rule, because of the rule that the time to file complaints doesn't start until the violation is discovered or should have been discovered. That could happen months or years, or I truly had a case where it was literally decades after a closing. That's when the cause of action was discovered, and that's when the time frame to file the complaint started. And so I think you ought to be keeping your records forever. Now, the good thing is you don't really have to keep, you don't have to keep paper anymore. A PDF is clearly a digital record, is just as good as a paper record. So scanning those things in counts. What people do is probably keep your paper file for, if you even ever had a paper file, let me start there. Keep your paper file for 6 months to a year, because that's when you're most likely going to get a phone call about it. or maybe until April 15th of the following year, because by then you know your clients filed their tax returns and they'll quit calling you asking for their HUD-1, right? And then at that point, scan it in and shred the paper and just keep the scan is what I would recommend. That is, in fact, what I do. I've scanned everything that I've touched for years and years and years now. I don't have any paper files. I've got digital files. So that's what I recommend. Okay. Next question. Go over the agriculture agency disclosure business again. And I'm cutting out. I'm sorry if I'm cutting out. I don't know. Hopefully that's not me doing it to everybody, but maybe it is, and I'm sorry if I am. I'm using this headphone thing so that we're not picking up background noise from here, but it could be me bumping it against my tie. I'll try to be careful about that. Okay, the agricultural exemption business is, yeah, it's a little bit of a headache to explain, but what they have done is they have defined pure agriculture, so not with a home on it, but agriculture, as commercial. And as commercial, it is exempt from agency disclosure. Now, what they have not done, is tell us what agriculture means. Certainly my grandfather's dairy farm was agriculture. Beyond that, it doesn't say. Now, I don't think the spare lot I have plowed up as a half-acre garden, I don't think that really counts as agriculture. But if you were on the wrong side of that, I'd make the argument for you. There's about the best answer I can give you on that. So the other question is, okay, what about this year time frame on claims against agents? Somebody here's more sophisticated than average, because they're asking the question specifically, what about the GLAR contract? Because it's got a mediation arbitration clause in it that says 365 days. And the answer is, though, that one is still, that's still going to be subject to the discovery rule. It's still going to be subject to when the defect was discovered. And by the way, what was discovered decades later, it was a very bizarre thing. This won't happen very often, but the young couple bought a house with a finished basement, and the basement looked, I'm going to turn my camera here, whoops, looked like this room. It was a walkout. So, you know, it had drywall on 3 sides, windows on the 4th, or maybe even had windows on 2 of the 4 sides. Drywall everywhere, even in the utility room. And the house was sold with the representation that it had a poured concrete foundation, and nobody could look at it and think otherwise, just offhand. More than a decade after the closing, they got a water leak in the basement, and they peeled open some of that drywall, and they found not poured concrete, but a very bizarre animal called a permanent wood foundation. And very bizarre. And whatever permanent wood foundations are, they're not concrete. They may be better, they may be worse, but they're not the same. And so that's what started the whole case. And anyway, interesting case. Okay, thank you for asking this clarifying question about the forms that are being required. The only form that is not being required are the agency forms. Okay, the seller's disclosure form, absolutely, you need to start using the new seller's disclosure form on June 1st. So thank you for asking that question. If you had it, others did. It's only the agency forms that you don't have to use the new agency forms until further notice. Keep using the seller's disclosure form. Absolutely, you must use starting June 1st. All right, I'm going to try something, and I'm going to leave my chat open for just a minute. at some risk of picking up background noise, but I don't think there's much here because there's not many people in this building. I'm going to and I'm going to see if that does any better. And maybe it'll stop cutting out because maybe it was me bumping my microphone. And if it does, okay, thank you, Norm. Maybe that was the problem. I thought I was curing it and I was making it. Okay. All right, let's see where we are here. We're back on. Okay, thank you for letting me know. I'm sorry that I'm sure that's very annoying, so I won't do that anymore. Okay. I'm gonna try to move this chat box. So the emergency order can be used to freeze the assets. And again, I think that's good for everybody with a license because it means it's your money, in effect, that it's getting used to pay for those things. Whoops, I got a, John, do you have a hand up that I need to, let me unmute you and lower your hand, see if this thing worked. John, are you, did you have a question?
Yeah, it was about the 365 days.
Okay.
I think you mainly answered it, but hypothetically, if we had a purchase agreement that said 365 days from closing, would that get overruled by the discovery rule in Kentucky?
Yeah, great question. The reason your GLAR contract is worded the way it is that everybody, all the lawyers involved are almost certain that if it said 365 days from closing, it would get stricken as illegal. I'll just use that sloppy term, illegal. And so that's why the Forms Committee has never changed it to say that, because this whole discovery rule is a function of common law, and there's some constitutional reasons that you have to say that. So that's why it's worded that way.
Just not my favorite. I mean, you have your strange walkout basement story, but you know, it still doesn't protect us as agents 2 or 3 years if the couple gets a divorce, they lose a job, and they try to poke holes in what the agents did.
Whatever's done, sure, absolutely, and obviously that decade when is kind of an aberration. I mean, I realize that, but I think it's very common for the problem to percolate up 2 or 3 years after a closing. Whatever the problem is, it's only when you discover the problem that your statute of limitations starts to run. So yeah. Okay, good question. Whoop, wait a minute. This thing is working. I think I got another question here. Darn it. Let me try. Well, maybe not. If you've got a question and I didn't see it, I thought I saw a hand go up and now I've lost it.
That was mine, Norman.
Oh, thank you, Norman. Yeah, fire away.
So I think it also said, or should have been discovered. So if they wait,
Correct.
then we are still protected to some degree.
Correct. And that's a great point. Let me give you an example of that when it's definitely happened, not even questionable, is I had as clients a Mr. and Mrs. Seller one time, and the buyers wrongly claimed that my seller failed to disclose that their basement leaked. And the buyers wrote a nastygram to my seller client on March 1st of 1998, I'll say. Said, you lied to us about this basement leaking. The buyers didn't do anything about it, or at least didn't file a claim until after March 1st of 1999. And the answer is, well, it's too late. You knew about it and you didn't do anything. You'll also get cases where we will know that the buyer knew about it because that's the day they called Roto-Rooter in, or that's the day they had B-Dry come in and treat a basement, or you can tell I'm kind of stuck on basements, but that is the most common complaint. So there are often times when they should have known they had a claim, and that does start the clock clicking. It's not just that they did know the claim, but they should have known they had a claim. So yeah, good point. Although I will say in today's litigious world, it's pretty rare for somebody to even think they have a complaint and not do something about it. But that's, you know, sadly, but there you have it. Okay, so yeah, we can freeze accounts, and if you're somebody who's had your accounts frozen and you don't think it should have been, you certainly have the right to get a hearing on an emergency basis. So it isn't like they're going to come take the money and put you out of business one day. Sadly, that regulation was passed because of somebody who was my client. They did not ask my advice ahead of time, by the way, because I would have told them either A, don't do it, or B, do it and then get the heck out of the country. You know, get as far away as you can. Go to Bolivia. Don't hang around here if you're going to do something like that. I would have told them not to do it. Okay, when the recovery fund is involved, when they do think there's fraud, it becomes a little bit more complicated because the complainant themselves are actually a party, and the KREC doesn't represent them, and because the KREC protects that recovery fund like it's their piggy bank, which in a way it is. I mean, not in a bad way, but and so the complainant at that point has to deal with everything themselves, and the KREC doesn't represent them. We've got a form, if we get that far, where a former assistant counsel to the KREC came up with a flow chart. Oh, you know what? Well, yeah, we'll wait until we're in forms to do that, and you'll see what a octopus convention the flow chart is. And but it's the first time they even had a flow chart about what this process is like. Okay, we've got again, a separate regulation about testing and education. I certainly didn't include everything in here. This again is something that Fader would have been very involved in, and I studied to some extent. But I thought there were a few things in here that all of you ought to know about. Beginning with, most importantly, I suppose, is that in order to in order to come out of, you have to have E&O insurance, you know that. And if you don't have E&O insurance, they're going to cancel your license. And in order to roll into inactive status, you have to have proof of that ERP, that extended reporting period coverage that we talked about. Now, that's not going to be a horrendously expensive piece of coverage, by the way. I mean, it's going to be about like your 1 year's premium on your regular policy. In order to come out of inactive status, you've got to have, to go into active status, you have to come out, you have to go through a criminal background check. Again, the people coming in from other states to get licensed, we're now subject to reciprocal licensing agreements, which we have one now with Ohio. And so anybody you know who wants to get licensed in Kentucky from Ohio, there's a specific process to do that. Unfortunately, there's not yet such an agreement with Indiana. I'm sure they'll come up with it. Many of you are dually licensed already. This does not affect you, but this is just people from now on who want to get those licenses. And they'll have to go through a criminal background check. They'll have to prove they were in good standing with the other state. And they'll have to take some education, and they have to pass the Kentucky law portion of the license exam, whichever exam they're coming to take, the sales exam or the broker's exam. And same thing's true for brokers. They have to have complied, show that they meet all the standards, have education, and pass the Kentucky law portion of the broker's exam. So it's meant to be a fair system. I don't think it matters. I don't think it's affected us a lot here in Louisville. Interestingly, I guess it's Northern Kentucky in particular that I guess gets a lot of Ohio people who want to get licensed in Kentucky. And I gather that Ohio and the vice versa has been very hard. For Kentucky people to get licenses in Ohio used to be very difficult, and we were being too easy on them. So now they've kind of made the slate level. Anything that you need to do with the KREC, you can do in paper, but you really don't want to do that. You're just inviting disaster. So there's all kinds of electronic applications to deal with, and you need to know about your OP ID number. That's, you know, how you are in terms of the professional license, which is what KREC and KREA are part of. So your online services portal. By the way, you really want to make sure and take a look at your portal. And if you don't have two email addresses on there, they strongly encourage you to get 2 email addresses on there, a business and a personal. Although I will say, in my case, I only have 1 email address. I just keep 1, and that's plenty. But if you have 2, you want to really get them both on there. The criminal background check is only valid for 90 days from the date of the record. And I guess there have been problems with people getting their criminal background check. And again, this, I guess, doesn't really apply to you because you're sitting here licensed, but people have had trouble, brokers, just so you know. And so there's a whole process here set up so that you can, because the fingerprints get rejected. I guess that's what it seems to be the problem of. So you can submit proof and keep moving forward with the license process by submitting proof that you did get fingerprinted and that they just didn't take for whatever reason. Of course, you're swearing that you don't have the criminal background and that you don't commit any violation. And then you do get to, of course, have to eventually get your criminal history affidavit done. And then you can move forward with your license. Just so you know, the criminal history that is a bar to getting a real estate license has changed. It's still 5 years on a misdemeanor, but it no longer is a felony forever. It's a felony within the last 10 years. And the KREC debated this a lot, and they decided if you had a felony more than 10 years ago, they weren't going to keep you out over that. If you have a felony within 10 years or a misdemeanor within 5 years, it doesn't mean you're automatically out. It means you're going to go through a review process. And there's an applicant review committee, again, a subcommittee of the entire KREC, that's going to look at that and make recommendations to the entire real estate commission. And again, they're going to decide whether you get your license or not. I made my note here that the 7 factors to consider were removed. What I mean by that is this regulation used to have a long checklist of the 7 specific factors the KREC was required to use when evaluating whether somebody with a criminal history got a license or not. So they've removed those 7 factors, and so now it's more broadly in their discretion to decide whether they think somebody should get a license even though they've had those criminal backgrounds in their history. And the review committee reports to the entire real estate commission, who decides what to do with that. Brokers, you have the right to release a licensee, and you may, and if an agent is released, they have 30 days to get themselves either reaffiliated with another broker, put themselves into inactive status, or if they already hold a broker's license, but they just weren't a principal broker, they can get themselves to become, they can open a principal broker office and become a principal broker. So they've got 30 days if you're ever released to do something, but you have to do something. If you don't, you're canceled. And once you're canceled, you shall not engage in real estate brokerage. So you don't want to let that happen to you. You're also canceled if you don't renew your license. So March 31st was the deadline to do that renewal. And if you don't, you're flat canceled. And again, at that point, you're prohibited from engaging in real estate practice. These are the reasons why you want your OP information up to date on the KREC website to make sure that you're in there, that they get you notification that you get renewed the way you're supposed to get renewed. If you have a change in your home address, you're required to give notification to the KREC of that. And you have 10 days to do it, but still a 10-day requirement. Also, we've talked about this. If you have a nickname or an alternate name, that has to be on file with the KREC. And if you change your name, which mostly would mean probably a marriage or the end of a marriage, you're now required to provide legal documentation supporting that, which interestingly enough was not a requirement in the regulation up until now. I'm sure they wanted it, but they really didn't have a regulation that said so. And all these changes have a $10 fee associated with them. Of course, brokers, you have the same duties. If you've got names or name changes, or you change your business address, there's another form for that you need to have filed. And as we've talked about, if you want to go into inactive status, that Form 201, which seems to be the form for almost everything, is the one that you use to do that. And hang on, we got a chat question here. Okay, so the question is, given that you have a 10-year only felony-free window to get licensed, may a broker during an interview of a prospective new agent ask regarding criminal history? Well, yeah, you could. Just because the license law says it's okay to have a criminal history older than 10 years doesn't necessarily mean you as a broker need to think that's okay. I'm not encouraging you or discouraging you from doing that, but you can have different standards than the KREC. You know, obviously they're going to be licensed, but you can say, licensed or not, I don't want, you know, I don't want you in my brokerage for whatever reason, right? So it's not like you have to take everybody who wants to be with you.